Okay, hello everyone. My name is Marcio Katz. I'm the CEO for GetGlobal International, a data privacy consulting company with operations in the US, Europe, and Brazil. And this is our first podcast, Get Privacy Cast. And we are happy to have as our first guest, Yugo Nagashima from Frost Brown Todd. Hello, Yugo. How are you today?
Hi, thanks for inviting me. It's nice to be here.
Okay, very good. Hugo, how you got involved with data privacy? Tell us a little bit about you.
Sure. So in my former life, which is just about a year or two ago, I used to be a intellectual property law attorney doing a lot of litigation involved in electronics. And as the GDPR came into effect in the 2016-2017 period, a lot more of IP started to cross over with privacy. And then I just got really interested in the subject and began studying it. And then I had the very fortunate opportunity of being part of the privacy team at Frost Brown Todd. So now every day in my life is privacy, and I'm just loving every day of it. So the real introduction is it was the cross between IP and data privacy, and it just crossed at the right point, and I made the move over.
Okay, that's very interesting. I think that we can say that you came from privacy by design, pretty much, when you have like both things together and think about how the device deals with privacy, or it was more because of intellectual property itself.
Well, I would say it's both, right? So intellectual property has always been about, at least on the electronic side, data. And data has been a big subject that I've followed. And how do you patent data, or how do you protect data? And then this protection aspect started to cross over with personal data protection. And people where I worked originally weren't really sure what to do with data protection because they thought more of an IP side. So I was tasked to look into it, and I found that it's quite different. And I dove into the subject. I really liked personal data protection, which we're going to talk about today, and that I got fascinated. And now I'm in this world of as a U.S. attorney, U.S. American attorney dealing with the CCPA, and also how do you deal with the GDPR, which I think has an international aspect to it, which I find fascinating.
Yeah, and talking about the international aspect of data privacy between the US and Europe, this is pretty much the topic that we are going to address today, the new transatlantic framework. But before we jump into this topic, I would appreciate if you could give us a little bit about the background. What came before this new transatlantic framework? How were the US and Europe dealing with the international transfer of data privacy previously?
Okay, so there's a lot of history, and I want to break it down into a couple of steps. There's a couple of eras. The first era was what was called the safe harbor era, the US-EU safe harbor era. And then there was a case called Schrems 1, which I'll go into more detail. And then there's the US-EU Privacy Shield era. And then there was Schrems 2, which I think everyone who's listening to this podcast will be familiar with. And then now we're into the stage of the transatlantic data flows era. So we're in the stage 3, the third sequel of this iteration of how do you resolve transferring data from the EU to the United States?
Mm-hmm. Okay, very good. Can you talk a little bit about the safe harbor and why it didn't work?
Sure. So let's just briefly start with the history of safe harbor. As most people are aware, everyone's aware of GDPR, but even before GDPR, Europe had a data protection So it wasn't a regulation, but a principle, the EU Data Protection Directive, which became effective back in 1998. So at that time, there was already this issue of, well, if you're going to protect data under the principles of the EU's Data Protection Directive, not the regulation, but the directive, how do you transfer data to the United States? Because you really don't have the same principles followed in the United States. So at that time, the Department of Commerce issued the Safe Harbor privacy principles, which basically took into consideration the data protection principles in the data privacy directive. And that was basically submitted to the EU, and it was approved in the 2000s. It was July 2000. So should I dive in more into the actual principles?
Yes, that's pretty much what we want to hear from you. What was this safe harbor about?
Sure. So the safe harbor was based around 7 principles. And I'm just going to first roll it off, and then I'll go into detail for each one of them. The first one was, so let's just go.
Okay, perfect.
Notice, 1, 2, choice, 3, onward transfers, 4, security, 5, data integrity, 6, access, we've heard of that word, 7, enforcement, and those were the 7 principles. So now I'll start with the notice aspect of it. Notice is, what we see today with like privacy policies, right? An organization must provide notice about the purpose of the collection. So, why you're collecting it, what basis you have to collect it, and the contact information for any increase in complaints, just like privacy policies we have today, and any third parties that the information is being disclosed to, and what kind of choices individuals have for limiting the disclosure, right? So essentially a privacy policy or privacy notice that we see today. The safe harbor rules said that you have to have that. Next, the choice is an organization must offer individuals with the opportunity to opt out from the sharing of personal information. And this is interesting, right? Because it's opt out and not consent, which is opt in. Right. As we will go onto the GDPR side, we know that you need consent, which is you have to opt in to let someone collect the information. But with the safe harbor, it was opt out, which is similar to what we have today in the CCPA.
Yeah, just one short comment on this matter. Under the GDPR, it's opt in when we talk about the consent, but we also have some other legal bases that you don't need to opt in, right? So it's a mix of both things. We could say that, right?
True.
Okay.
Correct. And next, onward transfers. So onward transfers is when organization transfers the collected data to a third party. For example, the best example that I think people can relate to is a controller transferring information to a processor, data processor, right? Or in the US, we would say a service provider.
Perfect.
And this, of course, under even the directive was that you have to let the individuals know about our transfers. You couldn't just say, hey, we collect the data, and if someone else processed it, you couldn't just stay silent about it. So the safe harbor principle also clarified that please inform that your information is going to be transferred. And of course, when the third party transfers happen, whether it's from a controller to a processor or processor to a processor, you usually state that, this is also GDPR and even in the CCPA, that you're going to use the same data protection principles or the same data protection, adequacy level that the controller has promised to and the processor is going to do the same thing, because otherwise, what's the point, right? You can have a very high standard with the controller, but as soon as it's being processed, it's a free for all, and that would not be adequately protecting the data. So that was another aspect. Next is security, And this is more of the data security aspect, that the organizations would take reasonable precautions when disclosing the data or transferring to a third party, and it'll protect it from loss or unauthorized access. Something we understand today as like breaches, right? And
Right.
then data integrity, also a similar concept to the more of the security aspect of it. Personal information must be relevant for the purpose, and it must be compatible with the purpose that has been collected. So if you promise to collect the information to, send a newsletter, right? It can't be used for like any other purposes. And this is more like in line with the GDPR. And if you're using it for other purpose, you have to again get a consent. But here, it's more general principle. They're basically saying, if you said that you informed an individual that you're collecting for purpose A, you do it for purpose A. And then access, which I think everyone, including the US and Europe, is aware of. Access is typically the data subject rights, right? The right to access, correct, amend, delete that information. And the safe harbor had a specific exception where they said where the burden or expenses of providing access would be disproportionate to the risks of the individual's privacy, which I think today it's a little different because usually you still have to give access, but that was part of the principles. And of course, enforcement. And this will affect a lot of things that we're going to talk going forward, which is they had a certain enforcement mechanism, but the enforcement mechanism here was recourse, verification, and remedies. And in the recourse mechanism, it was to have readily available, affordable, independent recourse mechanisms by which the individual's complaints and disputes are investigated and resolved. And the verification aspect is, follow-up procedure for verifying the attestation and assertions that the business make about their privacy practices. Because in the U.S. side, there's going to be a government regulator. In this case, it was the Department of Commerce that basically said, hey, are you really following the safe harbor rules? If you're not, the Commerce Department would check on you, right? They would investigate and say, well, you're not really doing it. And the remedies, obligations to remedy problems arising out of a failure to comply with the principles. So let's say the Department of Commerce investigates, and then lo and behold, the information that's being collected, they say they collected for purpose A, is used for purposes A and B and C and D and E, right? So then there's got to be a way to remedy that issue. So that was the safe harbor principle that was originally.
Perfect. Okay, very good. Do you remember any case that you have came across that the FTC, the commercial body, that has enforced the safe harbor? Any situation that you have seen during the time that the safe harbor was effective?
Yes. There's been cases. I can't name it off the top of my head, but the FTC has enforced under Section 5 of the FTC Act, and there's been multiple companies that have signed onto the safe harbor, and as we'll talk later, to the Privacy Shield, and then they would say that they would follow these principles, and typically the principles would be, they would disclose the information that they're collecting, which they sometimes did not, or they would only use it for the purposes that they were collecting it, and they would not, and the FTC would then investigate them and actually investigate, and put sanctions on these companies.
Okay, and why isn't the safe harbor, the agreement between the U.S. and Europe anymore? What happened then?
So what happened then is, I think one word, Schrems. Everyone knows the second one, but he was actually here first for the safe harbor rule. So there was a case called Maximilian Schrems versus the Data Protection Commissioner. And let me just give you a brief background with Mr. Schrems. So Maximilian Schrems is a privacy advocate from Austria, and he was very much concerned with a data transfer that was occurring between Facebook Ireland and Facebook US, because he was a Facebook user. And what really got him to file, a complaint, the logical complaint, was the Snowden revelations. So if anyone remembers Edward Snowden, he was the former, I believe, NSA employee who said, hey, the US collects data about, people all across the world, and there's certain programs like the Upstream program and other data collection program where, regardless, the US collects information. So he got really concerned about that news, and he basically said, well, the safe harbor principle doesn't adequately protect my EU citizens' data protection rights if Facebook Ireland has Facebook US process my data. So he lodged a complaint with the Data Protection Commissioner. And then originally, the Data Protection Commissioner rejected Mr. Schrem's complaint.
Mm-hmm.
So that's the story.
The beginning of the whole thing.
That's right.
And then he appealed, right?
Right. So just to give you a background, the reason that the Data Protection Commissioner rejected Mr. Schrem's complaint, and this will become one of the issues that was addressed in the case, is there was this decision by the European Commission, which is called Decision 2000/520, which basically said the safe harbor privacy principles between the US and the EU, that's adequate. That is just, it's protected, like it's good to go. So the commissioner said, well, I can't, if there's already a authoritative decision from the higher ups, I can't overcome that. I can't overrule that. So he said, hey, your complaint, is unfounded. I'm sorry, you can't there's no need for an investigation. So then Mr. Schrem says, well, that's not right. And he appeals the decision or this rejection to the higher court. And at this point, the high court, this is in Ireland. So Facebook Ireland. So one of the things I didn't say is the Data Protection Commissioner of Ireland, the court is in Ireland. The high court says, well, if this was under Irish law, yeah, the commissioners should have completely investigated it. Yeah, Mr. Schrems, you're right, but unfortunately, this is EU law, and because EU's decision 2005/20 is something that's, binding, we can't do much here. So what the court did was very interesting. They basically referred to the questions to the European Court of Justice and say, hey, do we have the right to determine, so is the commissioner is bound by the European Community finding, or can the commissioner, so the Data Protection Commissioner, say, well, I'm, regardless of I'm bound, if I think under, my understanding, so my determination, there is an issue there, I can investigate Facebook Ireland. Please let us know. So then the case, instead of just the High Court making a decision, in the US, the High Court would have had to make a decision and then have to go up on appeal, basically just referred it to the European Court of Justice.
Okay. Interesting. And then?
Okay. Yes. So then it goes to the CJEU, that's the European Court of Justice, and they basically said that the decision 2005/20 does not prevent a supervisor authority, in this case, the Data Protection Commissioner, from examining the claims of the individuals concerned. So basically said, yep, the commissioner could have investigated. They weren't just bound and they had to let it go, but they didn't. So they should really look at it again. But also the court went further, right? They said, well, the decision 2005/20, which is the one that found the safe harbor principles, adequate. The court says, well, decision 2005/20 is invalid, and it's not adequate because for article, so this is the directive. This is before the GDPR.
Yeah, before the
Article
GDPR.
25.6, which has very similar language for adequacy, would
Mm-hmm.
say that if to have adequacy in a third country means this, and I'm going to say, quote, let me quote this, I'm a lawyer, so I want to make sure I get it right.
Sure.
It's to ensure by reason of its domestic law or its international commitment, a level of protection of fundamental rights and freedoms that is essentially equivalent to that guaranteed within the European Union by virtue of Directive 95/94, which is the original directive, right? In light of the charter, which is the European Commission charter. So the key here is you have to have domestic laws and international commitments that are
Mm-hmm.
equivalent, right? Essentially equivalent to the guarantees that the European Union gives, right?
Mm-hmm.
So,
Yeah, because we got to remember that we are talking about a different legal system. When we talk about Europe, we have the European legal system and the country's
right.
legal system, right? And so that's why you were saying that they had to deal with both things. And this was the first, maybe the first issue that they have to address when it comes to what exactly we are talking about. Is it a local matter that can be dealt inside of Ireland, or this is something bigger, right?
Right. That's why it had to go up to the
Mm-hmm.
CJEU. So the issues with, based on that comment, right? And I think there's a lot more explanation in the actual decision, but I just want to pick up on some of the points that I thought, yeah, that makes sense to me.
Sure.
Looking back at it today is, well, if you remember the safe harbor principles, they're not domestic law or international commitment, right?
Right.
They're a government, certification, or government says, hey, companies, you can do this. Please follow these rules. And there is no, protection by a domestic law or international commitment. So, there, other than the Department of Commerce saying, hey, you shouldn't have done that, and we've seen the FTC go after it, there really isn't much of a protection. And we're going to see a lot of this play out in this decision as I walk through it. So it's a self-certification program. It's not law, right? Number one, the self-certification program only applies to those who self-certify. So if the companies don't self-certify, they're not bound by it. Department of Commerce can't go after them. And another important point that CJEU made was that this means the United States public authorities, which we're getting to, right? Intelligence agencies are not required to comply. That was one of the big reasons that they're like, hey, we don't think this is valid. And as we see in the future, for example, Canada, I think the public authorities versus the commerce is adequate, but the public authorities are not, I believe. You could correct me if I'm wrong.
Yes, that's right.
There is this distinction going on. And because Snowden brought the intelligence agencies issues, squarely into the question with the facts, I think the CJEU was really focused on, addressing that. Well, what about the government institutions? What's happening with them? There's also, safe harbor principles are also limited because, U.S. national security, public interest, or law enforcement requirements would always supersede the safe harbor principles. So even if the company said, hey, we protect them, if there's like a national security issue that, that will prevail throughout, because Schrems 2 also talks about it, the companies would say, well, have to follow the law. Here's the information. And that is what happens. Whether you consider that happening in every country of the world or not, a different question, but at least from the European perspective, well, it's not fair that the US government can access it and the EU citizens basically have, they just have to sit there and watch their information being taken or not even know about that, is I think the message there. And also there's no rule in the safe harbor rule that would interfere with the United States to protect EU citizens' right, which I exactly said, that was the issue. And this leads to, there's no minimum safeguards of the personal data of the concern, the data subject as we call it today, has sufficient guarantees enabling their data to be protected against risk of abuse and unlawful access, which is true. Why do we know that? Because the CJEU also said, well, there's no court that lets any European data subjects to challenge it or say, hey, that's not right. Please stop. They would have to go to the US, and the US courts would say, well, you're not here at that time, right? This is the part that's going to be changing, I believe. And there's no recourse or remedies just in general for individuals who have their information being transferred between EU and the United States under safe harbor. So that was the reason that Decision 2005-20, or we should just say the safe harbor principles were stricken down or found invalid.
Yeah, very interesting. And then, but it's still something that both parties they need to deal with. I mean, the U.S. and Europe, they continue to have to come up with some solution for the international transfer. And after that, they came up with the Privacy Shield agreement, right?
Yeah.
What was the Privacy Shield agreement different than the safe harbor?
Well, it's similar, but I think they tried to put additional protections to overcome some of the issues that were addressed in Schrems 1. So the Privacy Shield basically provided, EU individuals' rights and legal remedies. So they came up with the legal remedies concept, which is individuals may file a complaint to a Privacy Shield participant, and in response, the Privacy Shield participant must provide a recourse mechanism. Still sounds very similar, right? Still sounds very similar to Safe Harbor. The framework also allows an individual to lodge a complaint to the DPAs in Europe, and that DPA would then go to the FTC, and the FTC would then work closely with the DPA to investigate the matter. So there is a recourse mechanism now, right? The FTC comes into play, and the individual in the EU can talk to their DPA. So they don't have to go to the US or the courts to say, hey, my data protection rights is violated. They can just go to their DPA in their country. That's, I think, a difference. Also, the Department of Commerce committed to basically supervise the privacy framework, which I don't think that's that different from the safe harbor, right? Because they're the ones who came up with it, and so there's, as you know, Privacy Shield and Safe Harbor are both self-certification procedures, but the Department of Commerce said, hey, we will make sure that this will be managed, and if there's any issues with the self-certification process, we will investigate the companies that are claiming to be part of the Privacy Shield.
I see.
And also, there would be more strong cooperation between the EU DPAs and the United States, and also increased cooperation. Again, this goes back to the individual's rights point of FTC cooperation with the DPA. So the Privacy Shield established a point of contact between the FTC and the DPA so that the complaints coming in from Europe, right, from the European DPA, would be taken seriously and referred and investigated. I think that's one of the big differences.
And what about the government? I mean, did they change anything regarding the fact that the U.S. government they don't really need to follow the agreement?
So it's the Privacy Shield is, to me, it's a little unclear because there was some demonstrations of limitations of the national security and law enforcement aspect of it. The U.S. Intelligence Committee basically said, hey, they didn't promise anything, but what they said, they spoke to the European Commission saying, hey, there's multiple layers of constitutional, statutory, and policy safeguards that will not basically harm the data protection rights of EU citizens. And I think that is still the position today. The Privacy Shield framework also provides a specific channel for EU individuals to raise questions regarding the signals intelligence of the US. So that was another recourse mechanism that was brought in to address the Schrems 1 decision and the reasoning. So that's basically it. It's very light on the government side.
Yeah, you mentioned it, Schrems 1. So that means that there is Schrems 2. What happened then?
Okay, so Schrems 2 is a continuation of Schrems 1. Because as you know, as Schrems 1 decision came out, that was right around the time that the GDPR came out. And also the Privacy Shield came out in a very similar time frame as that was being litigated. So after the US-EU Privacy Shield was announced, the High Court, which basically the case was remanded, or the referral went back to the Irish High Court, said, well, let me just annul Mr. Schrems' complaint because now we have Privacy Shield. So, it's no longer
we don't have to address this matter because it doesn't exist anymore.
Because it doesn't exist anymore. So Schrems 2 concerns two issues, but I do want to focus on the Privacy Shield. Schrems said, okay, fine. There's another issue, which is the standard contractual clauses, which existed even from before. And also, oh, by the way, the US Privacy Shield. I have a problem with that. So he then filed a new complaint, and he said, well, the SCC, the standard control clauses, usually shortened to SCC, has issues because, again, there's what's called the Foreign Intelligence Surveillance Act, Section 702, and there's an executive order from the United States, Executive Order 12333. And basically, you just can't have international data transfers just by saying, hey, we agree to protect all these information, and we will do these impact assessments, and we'll make sure everything's free and clear, because the signals intelligence, the U.S. intelligence will always look into this issue, and if there's a reason for the FISA Section 702 to trigger, the information will be viewed by the intelligence agency. So Mr. Schrems still focusing on the intelligence issue, and the CJEU again. It goes back to the CJEU, and he argued that the Privacy Shield. Another argument he made about the Privacy Shield, and this is important, is it's only an ombudsperson and not a tribunal that provides, again, the same argument, essentially equivalent level of data protection under the European Charter, right? So he goes back to his main argument. Still not good enough. Which, again, if you remember from Schrems 1, what was the big issue? Is there a domestic law, or is there an international commitment?
Yeah. When we talk about international transfer of personal data for Europe, I think the most important thing is to be sure that the other part has the same level of security when it comes to the transfer of international data. And definitely when you have different standards, because the US way of regulating data privacy is totally different than the way that Europe regulates the same matter. Do you think there might be a solution in the future? I know we are going to talk about the transatlantic agreement, but
so I do think there is a solution, but I want to save that until we talk about the transatlantic.
Okay. So let's talk about the transatlantic agreement.
We have to talk about the validation of the Privacy Shield.
What was the decision itself, right?
Right. So I'm just going to go bullet point because it's very similar to Schrems 1. So the CJEU basically invalidates the Privacy Shield. As we know, that's why we're going to talk about the transatlantic data privacy framework. And the reason for that is, the FISA 702 EO 1233 does not provide the minimum safeguards, resulting in the principles of proportionality and limiting access of the information. And one of the key principles is, in Europe, you have this strictly necessary, right? The information that's being collected and processed must be strictly necessary. But these national security laws in the US, according to the CJEU, and again, there's different opinions, it's not strictly necessary because according to the CJEU, it's, hey, if the government agencies want it, they get it. I don't think that's necessarily the right characterization, but at least that's how the CJEU has taken it. And I think this is more important. There is still no effective redress. And I think that part, I'm very much in agreement with. There is no remedies for the Europeans, right? If you're a European data subject, you're not going to have a remedy. And there is no protection afforded unless you're in the privacy shield. Again, no different than the safe harbor issue. So those were some of the main issues. It's very similar. It's a rehash. So
yeah, it's very similar, right?
So now transatlantic data flow, right? What I would say is it's going to be a little bit different, hopefully, but maybe not. It's hard to say. One of the things we do know is the transatlantic data flow framework, if it's no longer a self-regulating process, right? It's not very clear. Then it might be an international commitment, right? Which is for the first time we will get to a point where it actually falls. Then the next question is, well, it meets the first requirement. It's a domestic law or international commitment. Is that enough, right? And then,
but at least it's going to be an international, commitment. So it's more, it sounds more of a rule that's obligated to be followed, right?
And that's what I'm hoping. We still don't know. We still don't know what the framework means. If they go back to just saying, hey, if it's self-certifying program, it's going to be a problem. But if it's an international commitment, as we've seen between the two, the U.S. president and the EU president, it will be different. Another thing we do know is that the redress aspects are now stronger, right? So we do know that So one of the three points made by the White House is strengthening the privacy and civil liberties, safeguards governing U.S. signals intelligence activity. So there's going to be strengthening of that to protect EU citizens and establish a new redress mechanism with independent and binding authority, right? So which the Europeans can say, they don't have to go to U.S. courts. It's not just asking the FTC to do something, but there's going to be a redress mechanism, which was a big issue. That's going to be addressed. So we're getting closer. It's getting hotter. We're getting to a better place, and enhance its existing rigorous and layered oversight of signals intelligence activities. So the part that Mr. Schrems is really concerned about, right, which is, what are we going to do with this signals intelligence? They're going to address it. The problem is we don't know how yet. It's still, we're still running, and we're told to, hey, look out for our framework soon, but we don't have much information at this point.
Very interesting. I'm curious to know, Mr. Schrems' opinion about this transatlantic agreement, because definitely there might be in the future a third case, or some other attorney may start a third case. But before we jump into what we've already heard from him, I want to know your opinion. What's your opinion about this agreement and how you would manage this whole thing? I think that everything is a little bit vague at this point.
Yes.
But I want to know from you what they should address and where they should get to in order to make this thing work.
So I think the general, the privacy community's thought is, well, this wouldn't be a big issue if U.S. could pass a federal law that would also, put in certain adequate, similar protections to Europe. But of course, that's a very long shot, and it may happen soon. It may happen not soon. We don't know yet. So I do think if there can be an international commitment, as we're hoping with this transatlantic data protection framework, things would be good. Also, the redress mechanism is very helpful, and that's going to be, I think, a key issue, because it always gets brought up by, Schrems 1 brought it up, Schrems 2 brought it up. And I think that will build in issues of, signals intelligence and, whether a European individual can, challenge some of the information collection. And if they can successfully do it and get a redress, I think that would address some of the adequacy issues. The other issue is obviously the strictly necessary. I'm not quite sure. It's hard to tell. Companies say that they do, but as you know, U.S. uses more of a opt-out system, right? So, I guess commercial organizations can say, well, I'm going to use an opt-in system, and that might suffice. But in terms of government, information is collected. It's hard to opt in, right? Because the information is collected, and there needs to be exceptions.
Yeah.
There needs to be an agreement between the EU and the US, and there needs to be clarity whether EU obviously has agencies too, right? Surveillance agencies and government agencies. We know that's very famous. There's a James Bond agency. Do they not collect it? Well, UK is no longer the EU, so not a good example, but I'm pretty sure other countries do too. What's happening there? Can the US put in a similar system, or is the system already similar? And is US just being targeted out because of the Snowden revelation? It's difficult to tell. But I think redress and having an international commitment to how we understand it, or how the CJEU has been saying, will be a very good first step. And again, Mr. Schrems will still challenge it. I think he's putting a lot of eggs in his basket, saying still signals intelligence, Snowden. But I think if the U.S. government and the EU government can work together to resolve those redress issues, we will be at a better place and a closer place to have an adequacy for the United States as well.
Yeah, and I think that we'll have to wait to see how Europe and US will address this matter, because the same thing will happen with some other countries. Right. Some other countries, they are regulated by GDPR-like regulations. They follow the same European standard. And that means that one of the principles is that if you are going to transfer personal data to another country, they should have the same kind of security when it comes to the way they are going to process the personal data. So if many other countries like Australia, Brazil, Argentina, and some other countries, they follow the GDPR-like regulation, that means that probably the US will have to sign the same kind of agreement with those countries. Of course, we're talking about smaller markets, but it's still the whole world is connected. So that means that probably the whole world will follow this agreement between Europe and the US, or maybe in the future, who knows, the US will move a little bit more toward the GDPR standard. And that means that we wouldn't need an agreement between both parts. Well, we'll see what happens in the future. So extremely and happily thankful for your time. It was very good, all the explanations and the opinions you gave to us. So thank you very much. Hope to be able to bring you back to our podcast. Maybe with Mr. Schrems, you never know. That would be a great debate. But I think that we started very well, for our first edition, for the first edition of our podcast. Once again, thank you very much, Hugo.
Thank you. My pleasure.
Okay. Thank you, guys. See you next time. Bye-bye.